All rise. Honorable Justices of the Supreme Court, hear ye, hear ye. All persons having business with this court are admonished to draw nigh and give their attention to the court now sitting.
Please be seated. Good morning. Nice to see all of you and we'll welcome you to the Supreme Court courtroom today for our 9 a.m. docket. For those of you who may be unfamiliar with our processes, I would like to explain that the justices have read and are familiar with the briefs of the parties, the facts of the case. We've reviewed portions of records as necessary, looked at authorities that are cited by the parties, and generally have a familiarity with the issues and that are being presented to us today, as well as our own personal notes that we've taken during that process. And we may be looking at many of those documents or things as we move through the oral arguments today. I say that because sometimes people wonder if we're distracted and not paying attention. But I want to assure you that when we are looking at our computers or our stack of papers beside us, we are indeed engaged in what the arguments are, and just using that to assist our understanding, to refresh our recollection of some detail. And we are still actively listening to you. I would also, before we start this morning, note that we do have an empty chair for the first case this morning. Justice Dandridge has recused on this case. That means that she will not be participating in the arguments today, nor will she in any way participate in the court's discussion of the case or in the decision writing of that decision. So with those preliminary matters completed, I would ask Mr. Doug Shima, the clerk of the appellate courts, to please call the 9 o'clock docket.
Thank you, Your Honor.
The first case on the 9 a.m. docket for Tuesday, March 28th, 2023 is appeal number 123100, State of Kansas versus Ronald Levon Buchanan, briefs both sides.
Good morning, and may it please the court, Emily Brandt of the Appellate Defender Office, on behalf of the appellant, Mr. Ronald Buchanan, present and ready for argument.
Madam Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff, the appellee in this case, the state of Kansas, present and ready for argument.
Second case is appeal number 123190, State of Kansas versus Jerry W. Campbell, briefs both sides.
Good morning, Your Honors, and may it please the court. The state appears by Assistant District Attorney Brian Dieter, present and ready for arguments.
May it please the court, Jerry Campbell appears through counsel, Casper Shire, Kansas Appellate Defender Office, present and ready for argument.
Your Honor, that concludes the 9 a.m. docket.
Thank you, Mr. Shima. We'll now call 123100, State v. Buchanan.
Didn't plan out just how big my binder would be. Good morning, Emily Brandt of the Appellate Defender Office, here today on behalf of Mr. Ronald Buchanan, the appellant, present and ready for argument. I would request 3 minutes for a rebuttal.
3 minutes is granted.
Although we are before you today on 3 issues, we intend to primarily focus our oral argument on the issue of first impression before this court. what is the unit of prosecution for arson? And are Mr. Buchanan's 6 convictions for aggravated arson multiplicitous? In the early morning hours of May 14th, 2018, a single fire occurred at the Spring Hill apartment complex. All the occupants of the building were able to evacuate, and that single fire resulted in Mr. Buchanan being convicted of 6 counts of aggravated arson, 3 counts of attempted first-degree murder, and 1 count of cruelty to animals. The double jeopardy clause of the Fifth Amendment and Section 10 of the Kansas Constitution protect against multiplicitous convictions. The test for whether a conviction is multiplicitous is found in State v. Schoonover. The parties are in agreement that the first 2 elements of that test are met. Here we have unitary conduct. There was 1 single incendiary fire, and the 6 convictions arose from the same aggravated arson statute. Therefore, the only inquiry before the court today is what is the unit of prosecution for arson? And the key to determining the allowable unit of prosecution under a statute is legislative intent. This turns us to the plain language of the arson statute. Looking throughout the arson statute, we can see that arson is by setting a fire or use of explosive devices damaging a building or property. Using this plain language, it is our opinion that there are at least 3 units of prosecution intended by the legislature here. It could be a building or property, how many buildings or properties were damaged by said fire, fire or explosive, the number of fire set or explosive devices used, or another person, how many people were affected by the fire. And even in the state's briefing, they argued that there could be at least 2 units of prosecution, a building or property, the numbers of buildings or properties damaged, or looking specifically at the aggravated arson portion of the statute, a human being, so the number of people affected. Cleaning up the statute, the Court of Appeals reasoned that the unit of prosecution must be a building or property, and that property must include an apartment located within a larger building complex, because an apartment is a dwelling, which is property. However, based on our position and the state's original position, we could end the inquiry here because both sides agree that there are multiple potential intended units of prosecution under the arson statute. And if it's not clear and unambiguous what the unit of prosecution is, that triggers the rule of lenity. And you would have to find in favor of Mr. Buchanan and vacate 5 of his 6 convictions for aggravated arson. If, however, you believe that the plain language of the arson statute does clearly define a unit of prosecution, we would think that the plain language does not support the position that a building or property necessarily includes a dwelling, because it's a lot of work to get the plain language when the point of a criminal statute is to provide a person of ordinary intelligence with fair notice that certain conduct is prohibited by law. If a person of
Don't we have to look at more words of the statute than what you've cited to us, though? Because the closing portion of 5812A1A is any building or property which, and this is the language I want to focus on, is a dwelling in which another person has any interest without the consent of such other person. Doesn't that really narrow the focus of and give a strong hint of legislative intent that what we're looking at would be the properties where there is an interest? And here we have the different persons who have an interest in the property.
Thank you, Your Honor. We would say that no. So when you're looking at the arson statute, certainly under A1, there are 4 subsections. 2 are to a dwelling, 2 not to a dwelling. Then we have 2 and 3, 1 to a dwelling, 1 not to a dwelling. And then we have the aggravated arson portion. And under that, we have the severity levels for all of those subsections. So to us, it doesn't actually narrow the focus of what the unit of prosecution is based on what subsection of arson a person is charged under. What that subsection does is changes the severity level of the crime that a person could be penalized for. When you're looking at the arson statute, I don't think that it's a fair interpretation that a person of ordinary intelligence is supposed to look at every single subsection to determine what the unit of prosecution for that subsection would be. It's our position that the unit of prosecution for arson is the same. no matter if you're charged under A1A, A1B, A1C, A1D, or B1 as aggravated arson. And so it doesn't actually narrow the focus by picking a subsection under A1. We would also submit to the court that the state didn't actually charge it under A1A. The jury instructions did not mention that the apartment unit was a dwelling. Nobody found that it was a dwelling. And so we think that there is, in this case, specifically no basis for narrowing it to subsection A1A and a dwelling.
How was the jury instructed? And does
If I
that
may
matter?
I think that it does matter. If this court wants to make a separate unit of prosecution for every subsection of the arson statute, then it would matter what the jury was instructed and also what the state charged. Here, the jury instructions say to, this is just jury instruction number 18, picked out of a hat. They all kind of say the same thing. The defendant is charged with aggravated arson, substantial risk. The defendant pleads not guilty. To establish this charge, each of the following claims must be proved. The defendant committed arson by knowingly, by means of fire, damaging a property. At the time, there was a human being in the property. The fire resulted in substantial risk to bodily harm, and this act occurred on or about May 14th, 2018 in Johnson County.
And was the property separately defined for each of the 6 charges?
Yes, it was. Separate, some of them say by means of fire damaging a property, specifically apartment 2203.
Okay. So
But
by the instructions, at least, the way the state argued its case to the jury was each apartment is a separate property under the statute.
or building. But yes, it would seem that they rely on property. It would also seem that the Court of Appeals relied on property and defined that property must include a dwelling. We also think that this can't be the legislative intent. Although the Court of Appeals looked at the definitions in KSA 215111K for dwelling, a dwelling is a building or portion thereof. And so the Court of Appeals has attached that version, a portion thereof, to include property. But if property is a portion of a building, we think that that renders a bit superfluous what building is. If building can be a property, or if building can be a dwelling, why does property need to be a dwelling? And if both are always dwellings, what is the point of in 2 subsections explicitly stating a severity level for setting fire to dwellings, and explicitly in 2 provisions setting fires to what are not dwellings? We think in this specific statute, the legislature meant something other than a building or a dwelling when they said or property. They were thinking of a car or some other personal property that somebody could set fire to or explode. We also think that for your consideration, that this court should consider that what the unit of prosecution under arson actually is fire or explosive. Consider the theft statute, which is 5801, which is also a property crime like arson. In State v. Hood, this court held that the conduct the legislature intended to prohibit was gaining unlawful authorization over property. And thus the unit of prosecution in theft cases is theft is the act of unlawfully taking property. In Hood, a patron of a restaurant went in, bought a drink, noticed there was a money bag floating around and thought, oh, I'll hang out, see if I can snag that money bag. The restaurant closes, the owner, manager, operator is cleaning up. She sets her purse on the counter and she sets the money bag on the counter and she goes to take out the trash. When she exits the building, Hood picks up the money bag and he picks up the purse and he leaves. He's originally convicted of 2 counts of theft, and one of those is overturned by this court as multiplicitous because what matters is the taking. He could have taken 5 things, or he could have taken something that was hers and something that was the bank's, the money bag and the money. That didn't matter. It's not 2 people that had stuff taken from them, and it's not 2 items that are taken. It's just the singular act of taking. Analogizing that to the arson statute, the prohibited conduct is setting fire or exploding any building or property. So thus the UOP for arson should be the act of setting fire or using an explosive device.
What if, how would that work in a scenario where, let's say we're not dealing with apartments, we're just dealing with single family homes. One fire is set to one single family home, and because there are high winds or whatever, it burns down the whole neighborhood.
We would submit that that's still one arson.
That
'cause-
is one arson, and the legislature did not intend for that person to be able to be prosecuted for 10 different home burnings.
Right, because the unit of prosecution in our mind should be the number of the act of setting the fire or detonating some explosive device. And certainly there are other ways in which people can be charged for damaging property. For example, if you look at the criminal damage to property statute, which is 5813, it covers all damage to property by means other than fire or explosive. Further suggesting that the unit of prosecution for arson must be this act of setting a fire or using an explosive device, because any other means of damaging property would be covered under the unit of prosecution in a different statute. There was one fire set on May 14th, 2018. One building was destroyed as a result. It may have included multiple units within it, but one building. So whether based on the plain language of the arson statute, the unit of prosecution is building or property or fire explosive, we submit that Mr. Buchanan's convictions for aggravated arson are multiplicitous. But if the unit of prosecution can't be determined based on the plain language of the statute, then the statute is vague, which triggers a rule of lenity. So this court must vacate under either theory 5 of Mr. Buchanan's aggravated arson convictions and remand for resentencing. I see that I'm out of time, but I will stand for any questions.
Under your construction, if I may ask one question, Chief, if an individual sets fire to just a single family home, and it doesn't do the extent of damage that the perpetrator intended, lights a second fire, which accomplishes the objective, then as under your interpretation of the statute, that then would support 2 separate charges of arson.
We believe yes, because then we have 2 fresh impulses. You said the first fire didn't work. You said a second fire, a fresh impulse.
It's the focus on the actus reus.
Yes.
Thank you.
Does it, looking back to the common law of arson, have any role in this? And recognizing that at common law, the focus really was upon habitation or occupation. And assuming that the legislature was just codifying that common law. Can we look there and does that help?
Thank you, Your Honor. I don't think that it helps in this situation because the legislature has so delineated what arson is in the state of Kansas. We now have, again, arson that is to a dwelling, not to a dwelling. We have arson that involves controlled substances. And then we have aggravated arsons, which I think maybe does go a little bit to the root of arson, and this fact that it's bad to burn down buildings that people are in. But I don't think that that necessarily changes the analysis, because the mere fact that a person is in the building is really a strict liability crime. A person is either in a building when you set it on fire or they're not. And secondly, it would probably lead to absurd results if whether or not there was a person in the building affected the unit of prosecution for arson. In this case, if you did the unit of prosecution for every person affected, Mr. Buchanan could have walked away with 18 counts of aggravated arson. Thank you.
Thank you, Madam Chief Justice, and may it please the court. I'm Jacob Gonteski. I represent the state of Kansas, the appellee in this case. Mr. Buchanan's multiple counts of aggravated arson, convictions of aggravated arson are justified and proper here because the actions that he undertook damaged the dwellings, the properties held by multiple different individuals, properties with different individual ownership and privacy interests, locked doors, and so on. And like our courts have said, when there are multiple private residences or private places, those can support multiple counts of burglary, for instance. Nothing is different here. And
So
what
it's
I'd
the
like,
interest that's important.
it is.
What about, I'll give you a totally separate hypothetical. Someone burns down my closet and I happen to have 5 dress shirts in there. I had an interest in all 5 of those. They're all property. Is that 5 acts of arson?
I don't believe as though it's 5 acts of arson necessarily, because when you look at the statute, what sets it apart from theft or criminal damage or other property crimes is the person element in aggravated arson. What Mr. Buchanan was convicted of was aggravated arson.
Yeah, but aggravated arson is piggybacked on the arson statute.
Correct.
So you have to have arson first,
True.
and then you get an added element.
Yes.
So, I mean, you could also imagine a person having been in my closet. I don't know why they would be, but I mean, that hypothetical still holds together. I don't understand why, if the unit of prosecution is property in which another person has an interest, why doesn't the burning of each item of property create a separate crime?
Because when you look at the statute, I believe the use of property in the statute doesn't envision the individual pieces of
Why not?
tangible
I
property.
guess is my question.
I guess going back to the Chief Justice's question, when we look at the roots of arson, what it talks about is things like dwellings or buildings or portions thereof. And that's what's going on here. This is, when I look through other crimes.
So I'm sorry to interrupt, but just pursuing the line of questioning a little bit further. If this person took my 5 dress shirts outside and just burned them, would that be arson?
I don't believe it would be.
Even though the statute just says by means of fire, damaging any property in which another person has an interest.
Well, I believe here we set it apart because it's a building, and that's the prong of the arson statute that we're talking about, is the building, the apartment complex that was burned. Whether or not burning your 5 shirts would support 5 counts or not, I cannot say at this point. This is an issue of first impression for this court, as opposing counsel opened with, which makes it an interesting one. And this court can find guidance in how it has addressed multiplicity issues in other statutes. And if you look through the Criminal Code of Kansas, they're separated by person and non-person felonies or misdemeanors. The state looked through, in looking through as many person felony statutes as I could that have been addressed for unit of prosecution analyses by this court. The only one I could find that did not envision multiple counts for multiple victims was the criminal threat statute that was addressed not that long ago by this court, in which the court said criminal threat, one threat communicated to a crowd will still only support 1 count of criminal threat, not 1 count for every individual that was threatened. That statute, though, stands apart in that what is criminalized in criminal threat is a threat communicated to another. And this court said, when you look at the meaning of another, it can be a person or persons. It can be single or multiple. And so the analysis was that statute was written by the legislature in a manner in which it's the communication of the threat, the single act that supports just 1 count. But when you look at the arson statute, we don't have that same ambiguity present, in which the legislature criminalized actions that impacted a person or multiple people.
Well, I'm sorry to interrupt, but doesn't any building or property do just that? The definition could refer to the collective, or it could be each. And isn't that the same analogy that you've just described with the criminal threat statute?
I don't think that's what the any means respectfully within the statute. I believe it means any property, as in we're not going to narrow it down between a trailer or a camper or a boat or a vehicle or a house or a condominium. And so within this statute, though, it is a person felony, like all other person felonies. This statute speaks of damage or a threat to an individual person. And when that occurs, and when you have cause that damage to an individual person's interest or threaten their life in this case, that supports multiple counts of aggravated arson. That's been the state's position all along, that the aggravated arson statute in particular, although it is a subset of arson, as Justice Stiegel mentions, what we're operating under here is the unit of prosecution for aggravated arson. That's the statute under which Mr. Buchanan was convicted. And the unit of prosecution involves either the different properties in which individuals had an interest, and there were multiple properties that different people had an interest in, or the number of individuals that were present, just like in other person felony
Counsel,
crimes.
let me ask another. It's another hypothetical, but thinking about potential consequences of the ruling you're asking us to make.
Yes.
If we rule in your favor and find there are multiple units of prosecution in an apartment building, how would that impact a future scenario in which an apartment building is empty except for one apartment on, let's say, the far west end of the building, and an individual lights a fire on the far east end of the building, and it never touches the apartment that the person lives in? Is that aggravated arson?
I
or
don't,
not?
I don't believe it would be then unless
Okay,
it,
so to be consistent, you're saying you're breaking that building up into multiple different dwellings, and if the fire doesn't touch the dwelling in which the person exists, you would say that a prosecutor could not come and bring an ag arson charge in that scenario.
in that scenario, I guess you could break it down two ways. You could either say the individual could be charged with multiple counts of arson for the different units that did catch fire.
But you can imagine a
Or-
prosecutor saying, look, this is a building.
Right,
There was a person in the building.
right.
That's aggravated arson.
Then that would support one count of aggravated arson for the envelope of the entire building, but not multiple counts of arson and then one count of aggravated arson on the end for the unit that wasn't touched. That would be my consistent argument, keeping consistent with the argument I'm making today. I believe it would be justified to either charge multiple counts of straight arson for the empty units if they burned, or not along with, or a single count of aggravated arson for the envelope of the entire building that contained an individual. Here, multiple individuals had an interest in that building, as the state has maintained all along. That's why it was charged the way that it was. And that's why the instructions that were offered to the jury that delineated the different units separated out the counts that way. Individual property interest holders within that building that were impacted. The gravamen of aggravated arson is the presence of that other person. It's not a property crime, it's a person crime. And that's what distinguishes it from theft or from burglary. Other multiplicity analyses that have been conducted by this court that found the individual act, the single act, can only support one count of theft or burglary in that instance. But multiple counts of aggravated burglary are justified if an individual breaks into multiple apartments within one building or multiple rooms within one hospital. That can support multiple counts of aggravated burglary. The same should hold true here for the burning of a building in which multiple people had an interest.
Opposing counsel, I thought, mentioned that there was no finding that this was a dwelling. Is that an issue in this case? And if so, was a finding made?
It was not raised as an issue in this case. I believe opposing counsel did correctly recite what the jury was instructed upon and the complaint language that was present in this case, but I don't believe as though it's pertinent to the analysis of this court in determining whether or not multiple properties were impacted for the multiplicity analysis. Mr. Buchanan never raised any instructional issues or instructional errors or concerns about the complaint below or to this court.
Your opposing counsel criticized, as I took it, looking at the definition sections as the Court of Appeals did. Have a response to that? I mean, does that seem like a logical place for us to look to determine legislative intent of what they meant upon a building or property?
I absolutely believe it's a relevant place to look. And it's relevant because that's what reviewing courts have done in other multiplicity analyses. The statute is the information that is available to the public. To the extent that opposing counsel is arguing the statute couldn't be interpreted by the public or by somebody that would be impacted by this or charged under these statutes. These definitions are part of the law. They are published. They're available to everyone who seeks to further understand the aggravated arson statute. And the terms that the legislature chose to use within this statute is another person in the singular, or in aggravated arson, for instance, committed upon a building or property in which there is a human being. If the legislature only wanted to criminalize and justify a unit of prosecution being one for the entirety of the building of an apartment complex, they didn't need to put or property in the statute, but they chose to do so. They could have just left it at aggravated arson, instead of in aggravated arson committed upon a building or property in which there is a human being. They could have said committed upon a building in which there was some number of human beings. If that was the language that was chosen, they would have a better case that only one count could be justified under the aggravated arson statute for a building containing multiple properties and multiple people. But the legislature didn't write it that way. That's the way they wrote criminal threat, for instance, when they spoke about a threat communicated to another, because just another can be defined as an individual person or multiple people under the statute. But when we look at the language used by the legislature in the arson statute, it is upon a building or property. So there must be some significance to the legislature choosing to include both of those terms and to include the next clause in which there is a human being, not any number of people, for instance. So the state maintains that this case was properly charged and the convictions should be affirmed based upon the number of properties that individuals held an interest. The state could have charged it as 18 counts of aggravated arson if it was arguing the number of people who were present in the building. But that's not the case here today, because if you look at the complaint and the instructions that were offered to the jury, it was the number of apartment units in which an individual was present.
So the state has an alternative to charge it, whether there's an individual interest or the number of people in the building.
That is the second argument the state makes in the multiplicity analysis. We've maintained that position at the Court of Appeals and here. That wasn't how the Court of Appeals resolved the case. And so we're just asking that.
But under your theory, if there was 150 people in that building, could have been 150. If there was an event going on in that building, it could have been 1,000.
Yes, absolutely. Because the gravamen of aggravated arson is the presence of that person. Now, to the extent that the argument is made that leads to absurd results, it's not an absurd result to convict somebody of multiple counts when they burn down a building in which there are multiple people. If there were multiple people inside, they could have been convicted of multiple counts of murder. And so if they had died, for instance.
Understand, that's a different statute. We're just talking about the one act of setting a fire.
Right.
Result in 1,000 convictions.
It could. If it killed 1,000 people, it could support 1,000 counts of murder.
I understand that.
Right.
That's a different stat, but
it is a different statute, but for the same reason.
Okay.
Were all the apartment units destroyed in this fire?
Or
at least burned?
Yes, that all of the 6 units for which he was convicted of suffered.
Were there
severe
other
damage.
units that were also burned?
I believe there may have been one or two that had nobody inside.
Do you know why they weren't charged?
I believe it may have, it's not in the record as to what the analysis was by the state, but it's not uncommon when looking at a case like this that carries 3 counts of attempted premeditated murder and multiple counts of aggravated arson that we're going to be topped out by the sentencing.
But I presume your position would be they could have been charged.
Absolutely. If empty units within that building were damaged by the fire, absolutely.
What if one person rents out an entire apartment complex? That only one charge?
It would seemingly be one because you have one person with an interest, with a property interest there, in which another person has an interest, is the language that's used by the statute. To the same end, I believe in the state of Kansas, under the arson statute, I don't believe it would be a crime for you to burn down your own home. because you're the one with the interest. So to the extent that in this case, the argument's being made, it would lead to absurd results. I don't believe that would be the case. We have, even this court is going to be hearing other cases this week on the docket where individuals were convicted of over a dozen counts related to a fairly quick subset of actions. And here, although multiple counts arose from this conduct, the sentencing guidelines and all the rules in place still prevent the state from pursuing, for instance, 6 consecutive sentences. It's not as though it will lead to an absurd sentence in Mr. Buchanan's case because of the guidelines prevent as much. When we look at other statutes and look for guidance on them, I believe it's pertinent to this court's analysis that this is a person offense. And that's why I'm asking this court to affirm Mr. Buchanan's 6 counts of aggravated arson. Recognizing I'm out of time, I'm happy to stand for any questions the court may have on that issue or the other 2 issues that were raised by the appellant. But absent questions, I'll remain tethered to the arguments made in my brief.
Thank you, Mr. Guntesk.
Thank you.
Grant, you reserve 3 minutes. That then the court will take this matter under advisement. By that, I mean that the court will now begin conferencing the case and we will work on a decision. That decision will be published, made public, be available for reading by anyone on our kscourts.org website or other locations. And we will issue a press release that notifies you and others that the opinion is there and available for reading. So thank you, counsel. We'll now call 123-190 State of Kansas versus Jerry Campbell.
Morning, Your Honors, and may it please the court. Before I begin, I just want to ask to reserve 3 minutes of rebuttal time.
Brandon.
So this case's procedural history is kind of important to this analysis, so I just want to briefly touch on that. This is the state's petition for review after the case was reversed in the Court of Appeals on a single issue, and that was the erroneous admission of KSA 6455 evidence. And when I say that it has a bizarre history, essentially the reason that the state brought a petition to review to this court was that the Court of Appeals entirely ignored a harmlessness analysis on that one issue. Essentially, their opinion found one error, and that was that erroneous admission of evidence, but they didn't conduct a harmlessness analysis, and that essentially flies in the face of precedent set by this court, Kansas statute. And effectively, that ruling is that, at least according to that opinion, would be that the erroneous admission of KSA 6455 evidence would amount to structural error. And that's why the state petitioned for review today.
Let me ask you a question right from the start. It appears from the briefing that you concede it was error to allow the 455 evidence in, correct?
Yes, for the purposes of this appeal today, the state is conceding that that was error. For the most part, I did find the Court of Appeals analysis compelling.
And the Court of Appeals, and then the Court of Appeals, although they said they were going to conduct a probative value versus prejudicial effect analysis in the cumulative error analysis, they never did that. What is your position on that? Would you, in finding that it was error to introduce it, would you also concede, for purposes of this argument anyway, that the prejudicial effect outweighed any probative value, and which would narrow your argument today to, even though the prejudicial effect outweighed that we still need to then conduct the harmlessness.
So I wouldn't concede that, no. Part of the harmlessness analysis is weighing the prejudicial effect versus the probative value. And I would say that here, there was almost no prejudicial impact, and we can look to the record and kind of.
But when you're talking about the prejudicial impact, and that's what makes this case so confusing, at least for me anyway, because I was really trying to ferret out the confusion of the analysis of the error in the probative value versus prejudice, and the harmlessness is that when you're talking about harmlessness, the state has the burden of proof to show that there's no reasonable probability that the error affected the trial's outcome in light of the entire record. So the fact that it came in, even though the prejudicial value outweighed the probative, or the prejudicial effect outweighed the probative value, did that change the outcome of the trial? Do you see what I'm saying? That it's.
I think so. And I guess I would say that, no, it didn't change the outcome of the trial, because there are procedural safeguards that were in place and that should have been in place in realistically any case that deals with 6455 evidence.
Well, so I guess what I'm saying is, I'm just trying to figure out whether you believe, do we need to conduct or remand, or, this whole prejudicial effect versus whether that outweighs the probative value? Because I have gone through meticulously, like the opening and the closing, and 3/4 of the opening and closing focuses on the May and on the priors, on the prior incident. I mean,
And
the whole case kind of focuses on these prior crimes.
And I see what you're saying, and it is a complicated issue because there's so many different factors and facts in the record at play. That being said, I think the record does conclusively show that there was almost no prejudice. There were those safeguards in place. For example, there was a jury instruction limiting the use of this evidence solely to the purpose of proving intent.
But there was also a jury instruction that said, in determining when defendant is in non-exclusive possession of drugs in a car, you can't infer that defendant knowingly possessed it. But here's what you can consider. Number one, whether defendant previously participated in the sale of drugs. And then number two, whether defendant used drugs. And there was no evidence that he used drugs. Whether defendant was near the drugs when they were found, but the drugs were found on the passenger side. So it seems like, the jury instruction right there said, number one, here's what you can consider.
Yeah, and for what it's worth, I believe that's from the pick, but
it was given to the jury to consider.
And I understand that. I understand what you're saying. That being said, the fact, I guess it wasn't in dispute at trial that Mr. Campbell possessed the methamphetamine. And I believe this is the case where.
Oh, it wasn't?
So essentially the Court of Appeals opinion was that the state opened the door to put his intent to possess the methamphetamine into dispute by admitting his own statements, his own innocent explanation to law enforcement. And essentially, because that was admitted by the state opened the door, at least under the Court of Appeals logic, to introduce that 6455 evidence. And that's why its admission was error here, because the state essentially opened the door for itself to admit this evidence. And beyond that, the possession wasn't necessarily in dispute, is more of the distribution, as far as I can tell.
Let me just ask you, once I interrupted your train of thought. Go ahead and finish your
So-
sentence. I know it's kind of hard to pick up. I did the same thing yesterday when I asked a question. Then I couldn't even remember what I was asking. So I'm sorry. Finish your train of thought, then I have a question.
I guess just on that point, had he disputed that he possessed it, essentially the only realistic means of doing that would to be providing another innocent explanation. And under that, the state could have properly admitted the 6455 evidence.
Here's my question as it pertains to 6455 evidence. Really, it's designed to only under specific types of exceptions. What it's designed to do is to prevent the state from admitting this kind of propensity evidence that has nothing to do with the case that's before the court or the jury. And that's essentially what it is. And once it is admitted by you that it's an error to let in this prior conviction, these prior acts or what it wrongs and convictions to show, and what it does is show propensity. How do we assess its impact when did not affect the outcome of the case? I mean, it had to have an effect on the outcome.
I don't believe it did. So essentially,
Okay, tell me why, because that's the danger of all this,
so
is that it does.
essentially, Mr. Campbell was charged with 2 counts of distribution of methamphetamine. This evidence was introduced solely to prove the intent and to rebut the truth or falsity of Mr. Campbell's innocent explanation. And the jury was instructed as to those purposes. And it's clear, just given their verdict, that they didn't use this solely as propensity. Instead, Mr. Campbell was acquitted of the distribution charges. He was convicted of simple possession of methamphetamine. And it's clear that the jury properly looked at that 6455 evidence and said, yeah, I'm not buying it. I don't see this as proving his intent to distribute on these days. Additionally, we have these 2 different dates already charged. So the jury already got a picture that he was picked up on, I believe it was September 23rd, 2017 and December 29th, 2017. So we've already got those in the jury's purview without the 6455. And that was never challenged. Those being charged together were never challenged in the district court, and they weren't challenged on appeal.
But wasn't there an innocent explanation? I mean, that was the defense. There was an innocent explanation. And that innocent explanation went to the question of possession, did it not?
Yes, and the state was the one who introduced it. And essentially, Mr. Campbell could have introduced that at trial, thus making the admission of 6455 evidence, at least in the Court of Appeals opinion, proper.
But that's not before us though, right? Or are you saying because of that influences the harmlessness analysis?
Essentially, yes. The possession wasn't in dispute. The simple possession wasn't in dispute. It was more the intent to distribute.
Well,
if the possession itself was in dispute, then the 6455 evidence would have been properly admitted because Mr. Campbell would have placed that intent to possess into dispute. But the entire argument on appeal is that it wasn't. But it.
Counsel, in trying to understand your argument, if I might paraphrase, and then you can tell me if I'm on the right track of what you're trying to say. In order for the evidence to be admitted, the judge is supposed to consider the probative value versus the risk of undue prejudice. So it's probative versus prejudice, and it's a risk of undue prejudice that is weighed. So, but then in considering as an appellate court whether the prejudicial effect under that standard, which is no reasonable probability that prejudicial effect outweighs the probative value. Are you saying that even though it was error, because the undue risk of prejudice outweighed the probative value, that the undue risk was not realized in considering all of the evidence, and therefore there is no reasonable probability that the prejudicial effect outweighs the probative value.
So I would say there is no real risk that the prejudicial effect, at least at the district court level, outweighed the probative value. And that's just given at the district court level, there was the innocent explanation. Obviously on appeal, that was a big issue because the state admitted that innocent explanation through one of its witnesses.
So the district judge is looking at a future risk, and an appellate court is looking at the totality of the evidence retroactively to see how it all played out.
Essentially, yes, because at the time it ruled on the 6455 motion, the district court had pictures, essentially a snapshot of the case given by counsel for both sides as to what was actually in dispute. But back on appeal, when we look back on this case, we see that the state opened the door to admit that evidence, that it wasn't actually in dispute because the state admitted that.
Why does that? I guess I'm confused as to why. Aren't we talking about the merits of the decision to admit or not admit, which is not before us, as
Yeah.
I understand it.
Yes.
Is that right?
And essentially I tried to avoid that, but it all bleeds together for an issue like this.
How does it, can you articulate how it bleeds together?
Yeah, so essentially with 6455 evidence, we have these limited purposes that it can be admitted for. When we look back on appeal and see, hey, that wasn't an actual purpose that it should have been admitted for, then we have to assess whether or not it was harmless for it to still be admitted, I guess, if that makes sense.
Is your argument that it could be harmless because it could have been admitted on a different grounds?
No, not necessarily. I think it was.
And once it's erroneously admitted, which I understand you've conceded to for
Yes.
purposes of this appeal, isn't the harmlessness analysis pretty straightforward? And it's just our standard.
Yes, it's the one from the statute.
And as I understand it, that's your primary complaint here, is that should have been done and it wasn't.
Yes, and it should have been found harmless, just given the totality, the context of the case in the record. Just looking at the outcome and looking at the evidence presented at trial, it's clear that this error was harmless and the jury didn't give it any undue weight. It's clear that they weren't persuaded by it, and it's clear that they didn't use it solely for the purposes of propensity. And seeing that I'm out of time, I'll stand for any other questions. Thank you.
May it please the court, Jerry Campbell appears through counsel, Casper Shire, Kansas Appellate Defender Office. This court should affirm the Court of Appeals reversal of Jerry's convictions based on the improper admission of KSA 6455 evidence.
Would you agree that that the Court of Appeals erred in not conducting a harmlessness?
I agree that they should have put in a sentence or a paragraph explaining why the error in this case is reversible. They should have done that.
Okay, and what is your position on harmlessness?
That this error is absolutely reversible because the state has not and cannot prove harmlessness.
So let me ask you this. When I'm looking at it, he was charged with from September, a count of possession of methamphetamine with intent to distribute, 2 counts of possession of paraphernalia. From December, same thing, and diazepam with intent to distribute. And then all this evidence came in about prior distribution. And I've gone through the record and it was all about, May and July distribution, money, scales, baggies, distribution in the past. And it's just full of all this distribution from May and July. And then the jury only convicted him of a lesser included possession of meth from September and 2 counts of possession of paraphernalia. and from December, a lesser included possession of meth. So, so when you say that isn't there some merit to the state's argument that it's harmless?
No,
Okay, so tell me why.
first, as Your Honor has laid out very well, I think a lot of this trial, opening, closing evidence, was about the improperly admitted evidence. Second, the split verdict shows that this was a really close case. It shows that the jury rejected the most serious charges. It shows that the jury returned lesser includeds on those charges and that they fully acquitted on some charges. And the really critical fact that I see, Jerry was acquitted of each and every charge that did not touch on methamphetamine in some way. The charges that he was convicted of all involve methamphetamine, whether that's simple possession or whether that's possession of the paraphernalia with intent to use it to distribute methamphetamine. He was acquitted of the buprenorphine charges. He was acquitted of the alprazolam charges. And I apologize if I'm butchering the pronunciation there. Yeah, well, I was kind of banking on that, to be honest, Your Honor.
And the 6455 evidence was all specific to methamphetamine.
Yes. It was, at least to my memory, I know it was at least 2 counts of possession of methamphetamine with the intent to distribute. So essentially the jury is looking at 2 different car stops. In the first one, Jerry is not the registered driver of the vehicle or the registered owner of the vehicle. He's not the only person that drives it, and there's evidence of that. After he stopped, he turns the car keys over to somebody else who refuses to consent to a search of the car. There are absolutely reasons to believe that what was found in that car might have belonged to somebody else.
But what about the fact that there was a card for the bail bonds person with his case number with the drugs on the non-exclusive possession?
Right, and that was the second case.
Right,
That was the December stop.
right.
And, I think all that shows is that somebody bonded Jerry out of jail.
But it was with the drug.
Yes, it was. So I think that could just as easily show that whoever bonded Jerry out of jail was in possession of that methamphetamine. And Jerry didn't bond himself out.
Okay. And then on the other one, it was exclusive possession.
I disagree, Your Honor, because Jerry was not the only one who had access to that car. It wasn't his car, and he wasn't the only one that drove it. And that evidence was in the record.
So the definition of exclusive possession is not who's in the car right then?
When somebody
Car
else
case law.
has a right of access or control over the car,
Oh, okay.
I think that could lead a jury to believe, well, we don't know that this was Jerry's. This may have been the car owners, or it may have been somebody else that was driving the car.
Okay, I also want to ask one question that opposing counsel brought up. Do you agree that possession wasn't in dispute?
In dispute is a term of art.
Uh-huh.
So in a sense, I do, because typically when we're talking about in dispute for the purposes of 6455, that means can the state admit priors to prove this point? And no, I don't think he put his intent in dispute for that purpose, either for simple possession or
Oh, I think I misunderstood. Okay.
but
Oh, so he was talking about the intent to possess wasn't in dispute. I thought he meant that your client was not disputing that he possessed.
Jerry did not take the stand and present any evidence at all. He didn't even put on an opening statement. So
Okay.
I don't think he put anything
Okay,
in
now I think I
dispute
misunderstood.
for that
Okay.
purpose.
But his counsel did argue to the court, we are not contesting possession or intent to possess or distribute. That was the argument that was made, was it not?
The closing argument was focused on the burden of proof and reasonable doubt.
But even the argument made to the court, when the court was considering the 455 motion, that was the argument, correct? Am I right about that?
I think the argument, I would have to look at it again, to be honest, Your Honor, but my memory of the defense was that the state can't prove its case.
Right, and
They're
that's
going to hold the
why,
state to its burden of proof.
that's why at the argument on the evidence, the defense position was, look, there's no grounds to admit these prior acts.
Yes,
Because
yes.
we have not put intent to possess or intent to distribute in issue.
Right, that's exactly right, Your Honor. Yeah, all we're doing is holding the state to its
Is
burden of
it
proof.
fair? And so then my follow-up, does it make sense to allow a defendant to make that argument below and then turn around on appeal and say, well, wait a second, we were harmed because this led the jury to conclude that we had an intent to possess or intent to distribute? Do you see the contradiction, or at least potential contradiction there?
I see the problem you're getting at, Your Honor. Here's what I'll say. I think they're two different questions, and I think we're all in agreement in this case at this point that this evidence should not have come in. That was error. The danger is that the jury is going to use that for propensity purposes. And
But do we know whether the error is that it was simply unnecessary or improper? Was it redundant or improper to admit?
it was improper. And this court's case law says that when the accused does not put his intent at issue by offering some sort of defense that opens up the 6455 evidence, it is improper to put on that evidence to prove something. Essentially, it's door opening, right? If the defendant takes a stand or puts on some other evidence, like in Rosa, that, well, yeah, that methamphetamine was in my house. I recognize that was my house, but I didn't know it was there. Well, then it becomes totally fair game to put on this propensity evidence to say, well, yes, you did. Where your defense is, the state can't prove its case. The state has not met the burden of proof. It is not fair game.
So in
put
the
on
harmlessness
propensity of
analysis, wouldn't it make sense to limit your position to whether or not the state made its case?
The state has to prove that the outcome would not have been different if this evidence had not been admitted. That's what the reversibility analysis is
Right.
about.
But
So-
are we limited by the way in which your client argued the issue below to simply asking, was the evidence the state presented essentially sufficient to support the charges?
No, a showing of harmlessness requires much more than a simple showing of
Typically it
sufficiency.
would, I agree. I'm just trying to get at this same sort of oddity of, which I think we're in agreement of, which is the analysis on the merits of the admission of the evidence turns on whether or not the defendant opened the door. It's a
Right.
good way to say it. I like the way you said that. It makes sense. And if the defendant's saying, look, I never opened the door, doesn't that, or I guess, tell me why that shouldn't constrain your arguments about harmlessness later on.
Because as you pointed out earlier, Justice, this jury it's expressly instructed that, hey, when you're considering non-exclusive possession, you can consider essentially the priors, you can consider prior sales. So the jury was told they could think about all of this stuff in determining whether or not Jerry was guilty of simple possession or not. So especially when you get acquittals on all of the counts that don't touch on methamphetamine, and the jury is told, well, you can consider these prior methamphetamine convictions to consider whether or not, when you're trying to decide whether or not he possessed this methamphetamine. I don't see how you can come to the conclusion that the state has proven that no other result was possible absent putting on evidence of priors that never should have come on in the first place.
Is there ever a scenario when it's harmless? And what I'm talking about is propensity of, of error to allow propensity evidence under 6455? What's the hurdle? I mean, we have a hurdle that's pretty high. Can it ever be cleared? In your mind, you started your argument by saying the state can't show it's harmless.
Yes.
Is that included in that calculus? It can't be, or the hurdle is so high it's rarely cleared, or where are you at with that?
I would say rarely is a good place to put it. And the only reason I don't say never is because I'm sure there's a case out there where the evidence would be so overwhelming that admitting priors wouldn't have made a difference. But this is certainly not that case, especially not given the split verdict that the jury returned. There's every reason in the world to believe that if the jury had not been that if the state had not been piling on with evidence of months earlier methamphetamine convictions, the jury would have returned acquittals just as they did for the other controlled substances.
Can you help me understand the limiting instruction limited to 450, the jury's consideration of the 455 evidence to intent and to prove the truth or the falsity of the defendant's innocent explanation? So was the innocent explanation a defense that was introduced at the trial by the defense?
Not by the defense, Your Honor, by the state.
The
And-
state said there was an innocent explanation for
Yes, and that
his
was
possession? I thought the innocent explanation was from his statement to law enforcement that other people are in this car all the time. It was probably them because it wasn't me and it wasn't the girlfriend.
exactly, but it was the state's choice to admit that evidence in its case in chief. Jerry did not put on that evidence. And he didn't have to. Obviously, he has the right not to testify. He gets to pick his defense. And that, I think, was one of the problems that the Court of Appeals noted here, which is essentially the state got to pick Jerry's defense for him and then rebut it with these priors. And again,
It wasn't the defense elected by.
it wasn't the defense selected by Jerry. It was the defense selected for Jerry by the state. And I see my clock winding down. I did want to touch on the two issues I had on the cross petition just very briefly. First, the state should not have gotten a chance here to relitigate a suppression motion that it lost. It shouldn't have gotten a second bite at the apple just because it didn't put on the evidence that it realized it should have the first time. Second, state erred by lumping Jerry in during voir dire with somebody who walks up to a court reporter and slaps her in front of a dozen witnesses in a misguided attempt to explain the presumption of innocence to the jury. And we endorse Judge Green's dissenting opinion on that point. We asked this court.
How much does the instruction on the presumption of innocence that the jury kind of overcome concern about the inquiry in voir dire?
I don't believe it does, Your Honor, and I see I'm out of time, but I'd certainly like to answer the question.
When are your response?
This was a case about reasonable doubt. That was Jerry's defense. So anything that waters down that presumption of innocence, anything that, you know, signals to the jury that, yeah, even though Jerry has a presumption of innocence, we know that even really guilty people where we have absolutely overwhelming evidence rely on that presumption too. In a case this close and in a case where the defense is reasonable doubt, that can't be harmless, Your Honor.
I'm gonna push back on that a little bit, because how was the presumption of innocence misstated? I think it was an inappropriate hypothetical, but how was the presumption of innocence misstated by that hypothetical?
Well, Your Honor, I think the key difference between the majority and the dissent here is that the majority is looking at the logical accuracy of the hypothetical. And I can't disagree that the hypothetical logically states what the presumption of innocence is. I think what the dissent does correctly is say, yes, but what we're really interested in is what effect does this have on the jury? And if the effect that this has on the jury is to water down the presumption of innocence and to edge the jury toward an emotional conviction, which for the reasons laid out in the dissent is exactly what happened here, that is error, Your Honor. And
So are you okay, like, how is it different from Robinson? In Robinson, which was a death penalty case with pretrial publicity, assuming the prosecution did a horrible or bad job presenting a case and you had serious doubts that the state met its burden, how would you vote? Or would you vote to acquit? There, we said that didn't alter the burden of proof or undermine the presumption of innocence.
And I think one of the things that makes this case different is we can see in the record that the jurors were in fact confused by this hypothetical, because the prosecutor follows up by saying, so if we presented no evidence and you had to return your verdict right now, what would it be? And the jurors are saying, I don't know. That's a tough one. I'm not sure how I would return my verdict there. And they had to be prompted on the correct answer before they got there. So, and Judge Green pointed out this out in his dissent as well. We can see in real time how this hypothetical is leading the jury off course.
But it's
Yeah.
also accurate that presumptions can be overcome. Presumptions have to be overcome with proof provided beyond a reasonable doubt.
Yes. Yes, but this particular hypothetical is lowering the bar before the trial starts. And that's the problem. that we
Why
have.
isn't it just simply demonstrating that a presumption can be overcome?
There are other ways to make that point that would not have watered down Jerry's presumption of innocence in the way that this hypothetical did.
Make a difference that the prosecutor didn't ask for confirmation that in the example, the person was guilty. That make a difference?
That she didn't follow up by saying this person is guilty, right?
To get some kind of a vote from the juror. Commitment. She didn't ask for a commitment from the
No,
jury.
she didn't ask for a commitment. And if she had, that would have been a separate problem. So we don't have that here. But we do have a hypothetical, which is, lumping Jerry together with somebody who is clearly guilty and is irrationally insisting on a trial anyway. And that is watering down the presumption of innocence. And I know that I'm well over time, so if there are no more questions, I'll conclude by asking this court to affirm the reversal of Jerry's convictions based on 6455 and to reverse the Court of Appeals on the 3 remaining issues. Thank you.
Thank you, Your Honors. I want to touch on a few points that were raised by Mr. Schreier here. I just want to address the 6455 issue briefly, since I spent the majority of my time, and I believe Mr. Schreier spent the majority of his addressing that. And I do want to touch on the cross petition as well. So essentially, we do have that instruction about the constructive possession that you can use prior bad acts to show constructive possession. However, the jury, again, already saw 2 separate instances where where it was alleged that he had possessed methamphetamine, and those were the charges from this case. Those were September and December. So adding another 2 dates to that, I don't think does any more harm as propensity evidence.
Okay,
as
so
far
I
as
don't
that's
really
concerned.
understand that argument, because that says whether defendant previously participated in the sale of drugs, and you're talking about the current charges. So in the instruction says in deciding in this case whether, the defendant is in non-exclusive possession. So I'm not really understanding how that,
I guess my
the
point is,
September, you know, this case combined the September and December charges together. So those are the charged crimes in this case. Those are not previous.
yes, and I guess my point is when you see something happen twice, when you see something happen once, you can kind of brush it off as an accident. Maybe it just got left in there by the registered owner of the vehicle. But when you see it happen twice in the same car with the same driver, the jury's already got this question. Okay, why does this keep happening? So we have those just in the charges, and that was never disputed. But then we have this 6455 evidence, and I don't think that adds anything else to it.
Well, why did the state want the 6455 evidence?
So I couldn't tell you, that much is not in the record.
Well, I
Well,
can
as
read the
far as
record and
the-
I have a pretty
and-
strong sense of why the state.
As
wanted
far
it.
as the proving intent to distribute and rebutting that innocent explanation that the state admitted. So that
It
would.
was a
that would be the
pretext,
purpose.
wasn't it?
Not as far as I'm aware.
Well,
But
and I don't mean,
those
to-
were
I don't
valid
mean to
purposes,
allege
at
bad
least.
motives necessarily. However, it seems clear that the state knew that it did not need to put intent to possess or distribute at issue.
So
It-
my understanding is this case was tried prior to this court's decision in Brazel, which clarified the admissibility of 6455 evidence in drug possession and distribution cases. Before that, everything was a little muddy and confusing. And so now we have this. And
Ma-
I would say there was no improper motive for the admission. I think it was.
And I'm not suggesting that, but I am suggesting that it appears to me that the defense, I mean, just in a run-of-the-mill case, if I'm a prosecutor, I used to be a prosecutor, if the defendant says, I just want to put you to your proof, it's like, well, that's a gift from a prosecutor's perspective. And here, it looks like you were like, that's not enough.
Well,
I
and
want 6455.
I think a
evidence too.
large part of it was one of the charges dealt with a weight of methamphetamine that was like 0.1 grams. And it was still charged at distribution. So the state didn't have any benefit of the presumption by weight as far as distribution goes. So I
In
think
other
that
words, it was a
part of
weak case, so you needed.
The
propensity
distribution
evidence.
wasn't the strongest. I'll concede that much.
I'm just pushing on a little bit on
I think
this
this is-
issue of doesn't the way, and I asked your opposing counsel this about the way it was argued below could cut against the defendant's position on appeal, but I think there's an opposite argument to be made that it really cuts against the state here. Because it just looks like the state really was seeking propensity evidence.
And
The rationale that we need this to rebut the innocent explanation, which we don't even have to put in front of the jury. It looks suspicious, put it that way.
And I understand. I guess my position here is that in every instance where it's determined that KSA 6455 evidence is erroneously admitted, there needs to be a proper harmlessness analysis. And I think this case has a strong argument in favor of harmlessness, just looking at the record and looking at the verdict returned by the jury and looking at the evidence that was presented. And that's why I'm here today. Just essentially, the Court of Appeals didn't do that analysis. And I would prefer for erroneous admission of evidence not to become structural error I'd prefer for that not to become
If
precedent.
we
so.
agree with you that the Court of Appeals made a legal error by not conducting that analysis, what is your request to us from that point forward?
I guess my request would be for an actual harmlessness analysis to be done, whether it's by this court or if it's sent back to the Court of Appeals to do that. Procedurally, I'm not sure how that would work, but it makes no difference to me. I would just like that analysis done. And so, seeing I have no time left, I just want to conclude asking this court to reverse the Court of Appeals reversal on the 6455 issue and affirm all of its rulings as to the other issues in the court's consideration today in the cross petition. Thank you.
Thank you to both counsel for your arguments. The court will take this matter under advisement. Court will now be in recess. We'll start our 10:30 docket a little late and take a 15-minute recess and resume it at 10:35.